rise.
Good morning.
Good morning all. This morning we have an appeal hearing in the case CFI-039 of 2018, Michael Page International UAE Limited and Currency Matters Middle East before His Excellency Judge Shamlan Al-Sawalehi. On the right, Your Honour, we have the appellant, Currency Matters, who is a litigant in person. Appearing today is Paul Sweeney. John Anderson is also in attendance. On your left, Your Honour, we have the respondent, Michael Page, represented today by Leith Ramsey.
All right. To start with, this is an appeal from the SCT, and I understand the appellant represented by itself, so it did not ask any law profession to attend this hearing. It could be for the cost matter, but the way how this court is run, normally we should receive an appeal bundle where that helps the judge and the court to identify all the documents submitted with skeleton argument for this hearing, but seems to me this is not being followed. This is to be noted in this recording. Plus, I've been told that there is some additional paper has to be filed of today's hearing. I will not accept any additional paper or any additional document whatsoever. I will run this hearing based on what I have in my bundle, which is the court bundle. This is why I want to make this note in the first. Now, as I said, this is an appeal from the SCT, and appealing from SCT is governed by RDC Rules 44.4143, which is allow the appellant to put his ground for appeal for specific reasons, and those reasons has to be either injustice of law or wrong of law rather than fact or evidence. Based on that, I would like the appellant to narrow his submission of today to those grounds. I've seen just recently, 5 minutes before I entered this room, I went through the grounds for permission to appeal, and as I speak right now, I don't see those grounds as really a real perspective for give permission to appeal to start with. But once the permission to appeal has been granted by the same judge who issued this judgment, Ms. Natasha, we are attending today's hearing with hope that the appellant would change my mind or convince me otherwise to look to those grounds for appeal again and make another mind, another view. Of course, we'll start with the appellant. I'm happy to have any 10 minutes background of this case, then go straight forward for those grounds for appeal again. Then we'll have another round for the claimant, who is represented by himself again, to give his opinion or his legal position or personal position, being a litigant person. So am I clear in my introduction?
I'm grateful, Your
Thank you.
Excellency, thank you.
Go ahead.
Your Excellency, in relation to one of the documents I was handing up, it is a document that is included within the court file. It's just a clear copy that may assist the court, and it's a copy of the board resolution. It was to assist the court that I wish to hand it up.
This one was already filed in this file?
It's just a clear copy of the document that's already within the...
Then that's fine.
Within the book.
Thank you. Okay.
Okay. Yes, Your Excellency, the background is that the claimant in this action, Michael Page, filed a claim in relation to some outstanding invoices that they say are due from the defendant, Currency Matters Limited, or Currency Matters.
Yes.
With respect to the claimant's position, the claimant relies upon a board resolution which has just been handed up to you, dated the 20.
The claimant relying on the board resolution?
Yes.
Oh,
Dated the 11th of January 2016.
yes.
And that's within their statement of the case, Your Excellency. It says that on the 1st of February 2016, the defendant, on the authority of Mr. James Anderson, CEO, to Mr. Jaswinder Singh, as per the board resolution dated on the 12th of January 2016, certified that Mr. James Anderson, CEO of Currency Matters, authorised Mr. Jaswinder Singh and Glenn Grant as a signatory on behalf of him. On the 23rd of November 2015, which is 2 days prior to the defendant being incorporated, there was a variation agreement that the claimant relies upon. And that variation agreement can be found as Exhibit 4.
Yes.
Of the of the appeal.
Yes. Variation agreement.
And the variation agreement varies an agreement between Michael Page and Currency Matters Middle East.
Yes.
And that's signed by Mr. Jazz Singh and a career in use of the claimant company. And it's stamped by Michael Page, but not stamped by Currency Matters.
Can you show me this in which exhibit, 1 or 2?
It's Exhibit 4.
Yeah? Where is this now? This is exhibit 4.
Of the appeal.
Yeah. What I should...
Do you have it, Your Excellency? Yes.
I'm seeing this in 23rd of November 2015.
Yes. And you'll see that refers to a contract that's allegedly in place between Michael Page International and Currency Matters Middle East.
Mm-hmm.
And if you look at the signatory
Yes.
on behalf of Currency Matters, it's Jazz Singh, position CEO.
Yes. What are we getting from this?
The claimant has no knowledge of this variation. They have no knowledge of what it was varying, the contract that's varying. If you look at the first line of the variation agreement, it states that this agreement represents the agreed amendments to the standard Michael Page limited terms and conditions, and then it alters it to 20% of an annual package. So that would suggest that there's a prior agreement in place.
Now, when you say the claimant has no knowledge of this, you mean your client or you mean the other side?
Sorry, I mean the defendant.
Yes.
My apologies.
Yes.
Your Excellency, yes.
I want to clarify. Thank you. Yeah, go ahead.
On the 22nd 2nd of June, which is the date that the defendant became aware that these 22nd of June 2016 was the date that the defendant became aware that Michael Page was alleging these debts.
I'm sorry to interrupt here. Just I want to clarify this. All this argument regarding the fact of signing this document or signing this, what do you call it?
Variation agreement.
Variation agreement. This argument already has been raised before the city judge, right? In the previous hearing.
Yes.
Yes. So, and this is a fact issues regarding facts, not law. You're talking
it's
about.
In relation to, it's in relation to knowledge of the claimant.
Right.
The knowledge of the claimant.
Yeah. You are.
And the interpretation that,
yes.
that the judge at the lower court placed upon.
In another word, when you say, I'm talking about this a particular document, variation, the 23rd of November, you position this signature of the defendant by name Jazz Singh is not true. This is what you're saying?
What I'm saying is that the defendant has no knowledge of that document.
Means he did not sign this document.
Jazz Singh signed the document and he signed it as CEO of
yes.
Currency Matters. Jazz Singh has never been CEO of Currency Matters.
Yeah, again, this is a matter of fact.
It's a matter of fact, yes.
Cannot be discussed in the appeal level. You know what I'm
yes.
going to?
I understand where you're going, Your Excellency, but it's a fact that needs.
It's not what I'm going. This is the rules.
Yes.
This is the DIC court rules when it's come to the appeal from a CT. You cannot go again and discuss the fact. You have to discuss the injustice.
Yes.
Or you can discuss, but this is an injustice meaning overall, not,
yes.
not related to the particular issue of the fact. Or you should say that the law applied in this case wasn't the right law.
Your Excellency, I'll refer you to, if I may, to the contract law and articles.
Yes, that will be useful.
Yes. And it's part 12 agency.
What I should look to?
It's part 12 of contract laws.
Yeah, part 12.
Yes. And Article 124 states that agency is a relationship which results from the consent by one person to another that the other shall act on his behalf and consent by the other so to act. It's the claimant's case that Jazz Singh was CEO of Currency Matters. Jazz Singh was never CEO of Currency Matters, and the claimant knew that Jazz Singh was never CEO of Currency Matters. And that's evidenced by the board resolution that they rely upon, which is dated the 12th of January 2016. And that board resolution that's just been handed up to you is an instruction to Emirates Financial Towers to allow Jazz Singh to sign documents in relation to the office being fitted out prior to the commencement of business. And it's only in relation to that particular piece of business.
Now, the problem is how we get to know whether the claimant, he knows about this or he doesn't know about this. This is a matter of fact. You make your submission based on the fact that the claimant knows about Mr. J's, where he was authorized to sign those invoices or not authorized to sign those invoices.
Well, the point is this, is that the claimant relies upon that document, that board resolution. It's in their claim.
Okay.
In that board resolution, it's quite clear that John Anderson is the CEO of Currency Matters Limited.
Okay.
Jazz Singh has represented himself to be CEO of currency matters. So there must be some due diligence that the claimant needs to conduct to ensure that they've got the right person here.
How he will do that? He will go and investigate in the
He would go on the
court
register.
you're working with?
He would go on there's public access to the register, and it states clearly who has authority in the register. And in relation to the agency rules,
Agency rules?
yes, consent, Article 127,
Yes.
an agency relation exists only if there has been consent by the principal to the agent that the agent may act on his account, and consent by the agent so to act. The principal here is Currency Matters. The only person with authority to contract is Mr. Anderson.
Okay.
Now, if we go to the invoices that the claimant relies upon, you will see, and these are at
Yes, you want me to see the invoices?
yes,
Which is this?
I'll just refer you to them. There, that's Exhibit 6.
Yes.
And you will see that
Exhibit 6 with some emails, then Exhibit 6, just some emails. I've seen the document start with the tracks. This is employment contract.
there's the invoices that the claimant relies upon in the action, Your Excellency. And there is
Just 1 second. Derek, please help me with this. Because I didn't find the invoice. So while we are looking for this, this board of resolution was issued on the 11th January 2016, which is basically say that Mr. Singh is not authorized to sign any invoices, right?
No, the board resolution says it's addressed. If you look at the address on the resolution, it's to the Emirates Financial Towers.
Now this is Mr. James, right? Yeah.
No, Mr. James and Mr. Singh could sign
Yes,
the document.
What I'm reading is here is clarify that Mr. James authorized Mr. Singh.
Mr. Anderson.
I'm reading this one, what I have here. This is invoice. So we're talking about 2 invoices. So that against to this, what you just handed to me, this is an authorization from Mr. Again, James to Mr. Singh to sign on behalf of him, right?
But only in relation to the Emirates Financial Towers.
Yes.
So it's a resolution authorising both Mr. Singh and Mr. Grant.
In the future, any comments? Yeah, I get you now.
Yes.
Any future had to be signed by both,
Yes.
right?
Yes.
Future mean after 11
Yes.
January 2016. Now those invoices dated.
I'm not, sorry.
Sorry, no, I'm just following the fact here, whatever it is, even if I didn't, just for overall understanding. It's from 11th of January,
Yes.
right? 2016 onwards, the Board of Resolution say that any invoices has to be signed by both persons, right? By Mr. James and Mr. Singh.
But only in relation to Emirates Financial Towers, because that's who it's addressed to. It's not addressed to Michael Page.
Yes. So why we then bring it in Michael Page case?
Sorry, Your Excellency.
What? You're saying this is only for Emirates Tower?
Yes, it's particular to Emirates Tower,
Okay.
and it requires 2 signatories.
Okay. All right. So you want me to see the invoices? Now I seen 2 invoices, I guess.
Which invoices do you have, Your Excellency?
Dated 18 January 2016. Both of them, I believe. In the amount of 55200. Do you have another invoice?
There are other invoices, Your Honor, yeah. And these are the invoices that the claimant relied upon. There are 7 invoices, Your Honor.
Because
Sorry,
we don't have a file in the proper way. This is why we going and coming. So where I should look now? Yes, maybe here's some exhibit 2, I guess.
It's exhibit 4 of the claimant's case.
Exhibit 3. There are some invoices 31st of January 2016 onwards.
Yes, they're the ones. Yes.
Yeah.
And you will see
How many of them?
7.
Just 1 second. I think in exhibit 3, not exhibit 4 of the claimant.
Sorry, this is on mine, it's exhibit 4.
Right? I'm looking for invoices with amount 68, then
Yes, we've got 31st of January to 68. And we have 29th of February to 17,000. 29th of February to 16,039.80. 29th of February to 68,000. 11th of March to 17,000. 11th of March to 17,000. 11th of March to 17,000.
just bear with me for a second, so I want to mark those. So let's go with those invoices. So what I have to look to?
So on the 23rd of November, which is the date of the variation agreement, it's acknowledged with the claimant that Jazz Singh is the CEO of Currency Matters. On the 11th of January, they acknowledge that John Anderson is the CEO by virtue of the board resolution, and that's what they rely upon today. Fast forward to these invoices, and you'll see that they're addressed to Mr. Jazz Singh as CEO of Currency Matters.
Okay.
And it's the defendant's case that the claimant knew all along who they were dealing with. They were dealing with Mr. Jazz Singh of T-Rex Trading. And the variation agreement, dated the 23rd of November 2015, was before the incorporation of the claimant company. It was prior to CMME. And that evidences the fact that there was already an agreement in place, which has never been provided to the court. It's been requested but never been provided.
Which one wasn't provided?
The variation agreement dated the 23rd of November.
So the Judge Natasha, she didn't see it?
Yes, she did see that. She saw the variation agreement.
Yeah, can you again?
Yes, it's exhibit
4, right? Exhibit 4?
4, yes, it is. Yes.
So you are, basically your argument today is that there is a document wasn't in possession of the Judge Natasha when she made her judgment? And this
Yes, there must have been a pre-existing document because it's varying in a contract that already exists.
Correct. This document now, why this wasn't represented before?
It's never been provided by the claimant. It has been requested by the defendant, but it's never been.
But that wasn't in possession of the defendant in the first place? The variation?
The variation agreement only came into the defendant's knowledge after the proceedings have been commenced by the claimant.
Yeah, before the judgment of Judge Natasha.
It was before Judge Natasha, yes.
So you have that document?
She had the variation agreement, but she didn't have the agreement that it's varying. So it must vary something.
Yes. Okay.
And the point is, what is it varying? And the claimant,
Right.
by issuing the invoices that you referred to earlier, the 2 invoices, I'm not sure what's happened, you've had my friend, your clerk here provided them to you, dated the 18th of January 2016.
Yes.
They're addressed to T-Rex General Trading.
Yes.
And that's fundamental to the defendant's position. Because that's evidence that the claimant contracted with Jesse and T-Rex Trading, not Currency Matters. And if he did contract with Currency Matters, then he should have conducted due diligence and he would have been told that no, there's never going to be any contract upon the set that you suggest.
Now, from my reading, I've seen something about contest jurisdiction. Application was filed earlier. Was something came from you as a defendant in this proceeding or in the SCT proceeding?
The jurisdiction?
Yes.
The jurisdiction point is not an issue today.
I understand, but that was something happened before, earlier.
Yes.
And the argument you make right now about the different party or the invoice different party, was the same argument made before?
No, it's not the same argument. It's nothing to do with the previous argument.
Thank you. Okay. Go ahead, yes.
The claimants had a pre-existing relationship with T-Rex and Jazz Singh.
Mm-hmm.
The claimants entered into contracts with Jazz Singh, invoiced Jazz Singh paid. Yet there's a variation agreement from the 23rd of November 2015, prior to the incorporation of the claimant company, claiming to be a variation to a contract that an entity that doesn't exist has entered into, signed by somebody who's never been an officer, employee or otherwise of the defendant company. Jazz Singh, via T-Rex Trading, entered into a service provider agreement with the claimant to provide a sales team, with the defendant, to provide a sales team to generate business for Currency Matters. And that's where we are. And it was up to Jazz Singh, under that agreement, to provide his own sales team.
Mm.
He's put himself out as the CEO of Currency Matters and engaged Michael Page to recruit people for him. Both parties here are injured. Michael Page has contracted with somebody who didn't have the authority to contract. Currency Matters are being sued for something that they never undertook or would even dream of undertaking. That's the position. In relation to the rules of contract law and agency, Article 129, creation of authority. Except for the performance of transactions required by statute to be authorised in a particular way, authority to do an act can be created by written or spoken words or other conduct of the principal. Now the principal here is Currency Matters. Mr Anderson is the CEO of Currency Matters and the only person with the authority to authorise an agent.
Yes.
Article 130, apparent authority, is the power to affect the legal relations of another by transactions with third persons, professedly as an agent of the other, arising from and in accordance with the other's conduct towards such third persons. There's been no conduct here by Mr Anderson to lead the claimant to believe that there's a valid agency principle invoked. Mr Singh represented himself as the CEO. So there could be no agency. He's the principal. He has to be the principal. There's no agency principle can be invoked. They rely upon agency, but they rely upon Mr Singh as the CEO. They know he's not the CEO because Mr Anderson signed a resolution for EFT on the 12th of January, so they know he can't be the CEO. That resolution requires 2 signatories in any event, but it's only relevant to Emirates Financial Towers. 131, creation of apparent authority. Again, except for transactions required by statute to be authorised in a particular way. Apparent authority to do an act is created as to a third person, i.e. Michael Page, by written or spoken words or any other conduct of the principal. Principal being Currency Matters, Mr Anderson, which reasonably interpreted causes third persons to believe that the principal consents to the act done. And it's the reasonably interpreted effect that Judge Natasha didn't take due consideration of. Because when you look at the evidence, there's a variation agreement, Judge Singh is CEO. There's a board resolution, John Anderson, CEO. And there's the service agreement with Michael Page and allegedly Currency Matters, the assignment confirmation. Jazz Singh, CEO, again. Now, referring that back to Article 130, reasonably interpreted, the defendants acted in a way that they did nothing. They signed an authority for Mr Singh and Mr Grant to have some phones installed at the EFT.
Okay.
That was it. They rely upon that as authority for Jazz Singh as CEO to enter into an agreement. Well, there can't be 2 CEOs, there can only be one. So reasonableness comes into it, and it's unreasonable for the claimant to suggest that they rely upon Mr Jazz Singh as the CEO signing these agreements, and they knew he couldn't be the CEO because they rely upon the board resolution.
Well, this will lead to the question, whether those agreements in your position valid or invalid?
Was what, sorry, Your
No,
Excellency?
the agreement you rely on, or the agreement you're just referring to, your position, those agreements are valid or invalid agreements between the claimant and the defendant?
Well, we said there was never any agreement.
You said there is no any agreement,
Never.
so no agreement existed.
No.
And this is why the invoices is, has nothing to do with the currency matter.
No. And they're addressed to Mr. Chad Singh as CEO. And he's never been CEO.
Now, this is another matter, whether those invoices addressed to whom. My question is whether the defendant already requested I don't know, this invoice, the matter of is that equipment fitting, or this is I don't know what the type of business the claimant is doing.
It's a currency exchange.
Yes. All right.
And it was basically there was a service provider agreement entered into with T-Rex Trading, who Mr. Chad Singh is the CEO of, for him to generate business on behalf of currency matters.
Right. So in your position, the defendant has never asked the claimant for any services?
Never.
Never.
And that's further evidence of that Judge Natasha didn't take into consideration, is the contracts of employment that were provided to the employees that were generated by Michael Page. The contract of employment was the T-Rex, not with currency matters, and they are as.
Yeah, I've seen it.
You've seen it? Yeah. So the contracts of employment that are generated by virtue of this recruitment drive,
right,
by Jazz Singh on behalf of T-Rex,
yes,
generated in contracts of employment between T-Rex and the people that Michael Page had recruited, never with currency matters. Currency matters knew nothing about it and wouldn't have known anything about it unless Michael Page had conducted due diligence, looked at the public register and seen that Jazz Singh isn't CEO, because doubt should have been in the mind.
all right,
It's reasonable that it should have been.
okay,
And in relation to the invoices that they rely upon,
yes.
and there are 7 of them, 2 of them,
Which is Justice Natasha, she's relying on her judgment?
well, she makes a finding in relation to the monetary sum.
Mm-hmm.
Now that has to be wrong, because 2 of the invoices are for the sum of 68,000 dirhams. One dated the 31st of January, number 775-3/10.
Yes.
And one dated the 29th of February, number 7877, both in the sum of 68,000 dirhams. And the narrative to the invoices says consolidated invoice, retainer assigned in respect of job title sales letter. There's no narrative as to who or what that those sums are due for. And Your Honour, sorry, Your Excellency, the claimant relies upon the board resolution as authority. In my submission, that isn't authority, it's addressed to Emirates Financial Tower, and Article 133 refers to incidental authority and when it can be inferred. An authority to conduct a transaction, including authority to do acts which are incidental to it, usually accompany it. or are reasonably necessary to accompany it. That is a document that's addressed to Emirates Financial Towers, nobody else. So it couldn't possibly be incidental to it.
Okay. You have further points to make, or we have to go?
If you just bear with me a moment, Your Excellency. Your Excellency, if it could be fair you to, it's the defendant's acknowledgement of service that's dated the 16th of October 2017.
Where I found that? Acknowledgement of service? Eric?
Sorry. It's down here. It's absolutely claim that the second acknowledgement of service dated the 16th of October. Maybe it's a bit too, is it?
Ah, that was in the SCT file. Do you have a copy of that? Yeah, just show it to me. Thank you. So, what the point you want to make?
The point I make is that you will see that there's an email from Michael Page acknowledging that a payment has been made.
Yes.
See, Currency Matters has never made any payments to Michael Page. That payment came from TRX. That email acknowledges that Jassim held himself out as CEO of Currency Matters. It's acknowledgement. Michael Page was duped. Currency Matters being asked to pick up the bill for that.
Okay.
And Judge Natasha didn't take due consideration to the court file and the evidence before her in making her decision. In relation to the board resolution, she said,
Yes. We can get back to you after like a second round when the
Yes.
claimant he can make his position and
I'm grateful.
argue his position. Yes, then we come back. Thank you. Yes.
Thank you, Your Excellency. As this is an appeal hearing, our position hasn't changed from a position of law and interpretation. We contest that Exhibit 1, which has been filed, which is the signed proposal for the sales recruitment contract, which doesn't actually refer to Jazz Singh as the CEO. It's signed by Jazz Singh. It has the Currency Matters official stamp, the same stamp that's in the board resolution, to conduct the search. So our position is that we are contesting work delivered based on the signed contract. And our position is against Currency Matters. So myself, having been in the region for 10 years, when we have a signed contract with the company stamp, we take that as a clear and present commercial contract, and that's what we're engaged in, and that's actually what we have delivered. With regards to the defendant's comments on being unaware of the engagement, Exhibit 5, which have also been previously listed. Yes.
Can just 1 second. Derek? Sorry to interrupt. Go ahead.
With regards to the defendant's position that Currency Matters and stands were unaware of this recruitment project, in Exhibit 5, launched with the court, there are numerous emails confirming meetings with the candidates and Mr Anderson, and indeed confirmation from candidates directly that they met with Mr Anderson. So we also contest that Currency Matters via Mr Anderson had no knowledge of this recruitment campaign taking place. So from a legal standpoint, we contest that Exhibit 1 clearly is a commercial contract with Currency Matters, and subsequent to that, all communication is on behalf of Currency Matters as explained in Exhibit 5.
We have 2 points here. The first one, the variation document we've just seen. Do you have any comments on that?
That variation document would have been for the recruitment of someone prior to the business, which would have been Catherine Rodriguez.
Yes.
And so there's no contest at all on that particular piece of recruitment. What we're here to contest is the signed commercial contract that you have in front of you, Your Excellency.
And what's your position for this board resolution document, Dr. Seer?
The board resolution document is part of the evidence chain that links clearly Mr. Jaswinder Singh as someone who can sign documents on behalf of Currency Matters.
For Emirates Financial Tower only.
Emirates Financial Towers. It also has the same stamp, which as an approval, which is the same stamp that's used in our commercial contract.
Okay. And you position the claimant, Mr. Michael Page. Michael Page is a company name, right?
Yes, sir.
They did already provide those services to the defendant.
Recruitment services. Yes, Your Excellency.
And they charge for those services directly to the Currency Matters. And this took place from which date to which date?
Sorry,
I mean, the services started from when to?
well, from the date of the signed contract.
Just refresh me again, from which date?
So that would be the campaign started on the 1st of February 2016. So once we have a signed contract, we're actually in a position to commence.
1st of February 2018?
16.
16.
Your Excellency.
Up to?
The campaign went through to approximately April, May in 2016.
Give me the date again.
around April, May.
9. April, September?
April and May. So the
April and
campaign
May.
started 1st of February and went through.
Up to May in 2016.
Correct. Yes, sir.
And during this time, how many employees did you submit, or did you serve, or did you?
So placements which were made. If I just refer back to the invoices. So
Now, are we looking to those invoices again? Those submitted
yes, sir.
since January 18, 2016. There are 7 invoices.
Yes, Your Excellency. So the first invoice is the 68,000 dirhams. So when we embark on a recruitment project, we ask the client to pay us a portion of the fee up front. That's so we can provide our services and allocate a team to deliver. So that's the first part of the commercial contract, which has been signed. We then have what is called the completion fee. So when a candidate starts in a position, we issue the balance of those of the assignment. So in this instance, we have invoice 1, which was 68,000 dirhams. So that's to commence the recruitment project and for us to allocate manpower to pick up that project and deliver it. And then the next portion of payment is when candidates actually start in the position. And those invoices are Nathan Toms, Sophia Khan, shortlist fee for once the actual list of candidates presented are delivered, Nathan Green, and Mr. Richard Crooks and Martin Smith.
Now, just so I know, all of those candidates, if you like, or proposed names, been hired or they secured a job?
They did, Your Excellency.
All of them?
Yes, Your Excellency. I believe there may have been one candidate who had an issue with getting the appropriate visa through at the time, but all the other candidates went through the process.
Now, the amount for those invoices are just amount for providing the defendant with the CV and background, or that involve extra services?
So our role in this is to meet with the client, understand their requirements, go to the market, and then present a short list of candidates. And from that particular short list, the client will then take, will then interview who they feel are the strongest ones. Once the client interviews those candidates and makes a formal offer, we then do the offer management process, and then we help the candidate, if they're working, go through the resignation process. We make sure that they start with the organisation as well.
Now, why I'm asking this question, I want to see any sort of evidence or document or correspondence came from currency matter after you providing them with those candidate lists, in terms of any feedback or any further requests from them to you.
Sure.
So we need to see some sort of evidence where the defendant really get to engage with your client.
So in Exhibit 5, which I believe will be part of your bundle.
Well, that will be a little bit slowly with me because it's not organized file. Where I should look now?
So in Exhibit 5.
Exhibit 5.
Yes, Sir Excellency.
This is Exhibit 5 for permission to appeal, but maybe there is another Exhibit 5. Yes. After the invoices,
it's separate to the invoice, so in this particular bundle, the invoices are labelled as Exhibit 2.
Please. So I'm looking through this email dated 14 February 2016 from Katrina.
Yes. So Karina was our employee. Our manager at the time, Catherine Rodriguez, was an employee of the defendants, and it confirmed that the candidates that we had put forward were well received, and then that they would be doing a Skype interview with the CEO, John Anderson, and they would get back to the availability. Then it mentions the candidates' names underneath that.
So the email said there will be a Sky interview with the CEO, John Anderson.
Yes, Your Excellency.
So how can you explain the difference between this fact and invoices being addressed to Mr. Singh as a CEO?
How do we?
So we can explain.
So that is the title that's been put in our system. So as an organisation that was set up, our view that was that Currency Matters Middle East was being represented by Mr. Singh.
The contract signed by whom?
The
agreement, the service agreement.
So the service agreement was signed by Mr. Singh with the Currency Matters DOC stamp.
Under which capacity he signed the agreement?
There's actually no designation, so it doesn't actually say CEO Currency Matters Middle East. If we refer back to the commercial contract, it's Jaz Singh and he's with the DOC stamp. So we then take that to mean he is the legal and lawful representative of Currency Matters. We then interviewed the candidates. The candidates then were selling on behalf of Currency Matters, which is why, in our opinion, when we look at the signed contracts, candidates meeting Mr. Anderson, candidates presenting Currency Matters as a product to the market, all the emails are via Currency Matters. There's no mention of T-Rex, there's no email addresses around T-Rex. Our view is that it's beyond reasonable doubt that we were acting in providing recruitment services to Currency Matters, Your Excellency.
Is there any consideration or thought that Mr. Singh is just a middleman?
No, Your Excellency.
You don't think so?
No, there was no consideration.
Can I see again the agreement? Can you take me to the agreement? Just so I have a look. I don't know where they submitted. It's two commercial agreement or one?
So the one, Your Excellency, so Currency Matters, one that says 10 times sales executives. This is the commercial contract.
Because we have the position of the other side denying existence of this agreement.
Correct.
All right. Can you take me to the signature of this agreement?
Sure. It's the very last page.
Okay. Last page. Is it? Assignment confirmation, right?
Yes, Your Excellency.
This is on behalf of currency matter only stamp. Right?
Yes, Your Excellency.
So and what's your position saying that why there is no, or asking why there is no signature from the other side?
There is, Your Honor, it is underneath. It's just it's an old document, but the copy is not very clear. So you can actually see the Michael Page stamp and the signature of Kareem Newsom, who was the manager of that particular team at the time.
Manager, King. Now this agreement dated on 1st of February 2016,
Yes, Your Honor.
and before this date, the claimant used to work or used to have another engagement with the defendant. I'm looking to this variation. There is a document called Private and Confidential dated 23rd of November 2015.
Yes, Your Excellency. So that particular.
So what I want to know, before the 1st of February 2016, before this commercial deal or this commercial contract,
Yes.
does the claimant have a previous relation with the defendant? In terms of, there's another engagement before or another commercial contract before?
Well, for currency matters, yes. Working through Jazz. So Your Excellency means, are we recruiting for Jazz Singh? Yes.
No,
because we
not
work
the adjustment for the currency matter.
for the currency matters.
Have you worked with have you made any commercial contract with them before this contract?
Yes, Your Excellency. So we recruited a lady called Catherine Rodriguez, who was the executive assistant. So that was the first position that we recruited for the organisation.
That was based on commercial contract or just one time?
Separate contract. So our first piece of work that was completed for
Yes.
currency matters was the recruitment of Catherine Rodriguez. So
Okay.
because that was a successful piece of recruitment, we were then asked to come in and discuss how we would manage this particular sales project.
And I assume that you've signed a contract with the currency matter. When you, before you provide them with this lady, you've signed with them a contract.
And that's the variation agreement that you're referring to.
Yes, I understand. But before this variation agreement, you signed with them a commercial contract, no?
No. So that particular variation agreement is the first commercial contract that we have had with currency matters.
Okay.
And that related specifically to that first piece of recruitment that we did. Subsequent to that successful piece of recruitment, we then were engaged on this sales campaign. And so the commercial contract that's in contest is the sales campaign. Nothing prior to that. Your Excellency.
Yes. And before this 1st of February 2016 commercial contract exists, you dealt with the defendant, and the defendant was represented by Mr. Singh.
Yes, Your Excellency.
As to the variation contract or
Yes.
agreement,
Yes, Your Excellency.
signed this in position as a CEO, but the defendant, I think they, just refresh my mind, this document, the variation one, you say It not exist, or
No, the company didn't exist until the 25th of November, Your Excellency. And it wasn't actually authorised until it was the 2nd of January.
25th of November.
16th of January 2016, when it was first able to trade. I will come back to you on the point
Yes.
that my friend makes.
So for this commercial deal, how been? I mean, did the currency matter they approach your client, or your client approach them, or how?
So so originally we were approached to recruit first position, which was an executive assistant, and because of our reputation and DRC location, we have a lot of clients come to us who want to work with us. That was fantastic. Currency Matters were a well-known brand in the UK. They're setting up out here, so we love working with new organisations, particularly being a British company where there's a link, there's an extra bit of interest there. So that first transaction was fantastic, very smooth. So there's absolutely, from our side, no contest or ill feel to the first, I guess, commercial contract that we had and the delivery of that. Our main point, Your Excellency, is around the sales project commercial contract that we had.
So you have a commercial contract signed by Mr. Singh, which the defendant company say he not authorized to sign this in first place. Plus they denying this contract. Generally they say this contract was not signed by us, even though there is a company stamp on this contract. Then you show me a sort of email came from the defendant company acknowledging that you provide them with a CV and they're going to set up an interview with Mr. Anderson, being the CEO of Currency Matter. That was in February 2016. Only one email you have? Or there is a different email? To show that there can some of engagement between your client and the defendant. I've seen another one.
My approach?
Yeah. I think what I'm seeing is right now.
Okay, thank you.
This is another email came from Catherine on 17 February 2016. We are pleased to confirm we have selected the following candidates to join our Currency Matter Middle East team: Martina, Nathan, Seth, and Nathan Green. Did the defendant pay anything up to before you filed this claim?
No, Your Excellency.
So this amount, 220 or something dirhams, is all overdue amount,
Yes, Your Excellency.
not part of any.
No. There's been no reduction there's been no initial payment as per the commercial contract.
Right. And your client business, they don't ask for any upfront payment or any deposit or whatever, like this type of things?
Are you talking about a bond?
Yes.
Yes, no, Your Excellency. A bond, we see some government clients in the Kingdom of Saudi Arabia and the United Arab Emirates will ask for a bond, but in the private sector, that's not something that we see, Your Excellency. In my 10 years here on that, Your Excellency, I've probably had 2 clients, one in the Kingdom and one in the UAE.
Okay. Okay, do you need to address me with any further points? Or
No, Your Excellency.
Yeah, thank you very much.
Thank you.
All right, so you've had the other side position. If you want to comment on this, please go ahead.
Just briefly, Your Excellency, I won't keep you. They rely upon the stamp on the documents.
And emails.
And I'll refer you to the emails separately. But in relation to the stamp has never been provided to Mr. Singh.
Maybe he stole it. This is the
that-
action you have to take against.
It is, and that is underway, Your Excellency.
Okay.
But in relation to contract, you need authority. There's never been any authority here. And I refer you again to part 12. My friend refers to Catherine Rodriguez, and he says that the first
Yes.
dealings that they had with the defendant was the deed of variation. But that simply can't be so. It's impossible for the first dealings to be the deed of variation. You must have been varying something.
All right.
It must have been. What the defendant doesn't know, because the defendant has no knowledge, has requested details, it's never been provided. The defendant then goes on to say that they acted for currency matters in the recruitment of Catherine Rodriguez. That's simply not true. Catherine Rodriguez was employed by T-Rex General Trading, and that's evidenced by the invoice that the claimant sent in regards to her recruitment, and they were within the bundle, and they were the 2 invoices you referred to earlier, Your Excellency, dated the 18th of January 2016.
Yes.
And you'll see there's an invoice, and it's made out to T-Rex General Trading, and it's to Mr. Jas Singh, CEO at Emirates Financial Tower. And if you look at the address, it's the same address as the defendant's.
Okay.
Mr. Singh was operating as a middleman, as you put it, between clients and currency matters. The claimant was aware it was T-Rex General Trading, and if it needed any evidence, that invoice is evidence. That invoice wasn't paid by currency matters, that invoice was paid by T-Rex. It was made out to T-Rex, it was paid by T-Rex. The next association that Mr. Singh had with Michael Page, Mr. Singh decided to use currency matters as his conduit without any authority.
Can you explain this further, how to use it?
Pardon?
Can you explain this further, how he using this as a conduit?
Well, he enters into an agreement with Michael Page under the banner of currency matters with no authority.
Right.
Under the service provider agreement, he had no authority whatsoever to enter into any contracts.
I understand your position. You're actually not acknowledging this agreement as at all.
Yes.
So
Yes. Yes.
let's see what's happening afterwards.
Okay. Afterwards, Catherine Rodriguez, Mr. Singh, and Umar, yes, Umar Ridge, were all employed by T-Rex. The people who sent the emails had an email account under the Currency Matters banner, but they were working for T-Rex.
Hmm? Are you speaking about the same emails we just been discussing?
Yes.
Can you explain this further? So I'm looking for this email, top name Nirvana, right? So we have an email from, this is a Hotmail. Okay.
If you look, the email is from Catherine Rodriguez. And then if you go back to the invoice that I referred you to earlier, you will see that Catherine Rodriguez was employed by T-Rex. The invoice was made out to T-Rex.
No, I'm looking for this from Catherine Rodriguez. Her email is at cmme.a.
Yes.
This is the email of matter, currency matters.
It is, yes.
So now, how you explain this is?
She had access to a Currency Matters email account.
So you're using an email without authority to use this, or I'm not getting the picture.
Yes. She did have authority to use the email, but she wasn't employed by them. Her employment contract was with T-Rex. As Your Excellency, were all of the other individuals that Mr. Ramsey refers to. All of their contracts of employment were with T-Rex. They weren't with Currency Matters.
But then why the Currency Matters give permission to someone to use an email of Currency Matters company while they are not working for them? This is very highly risk, so I'm not sure how this.
Yes, it allows them to explain the relationship between those and clients. It was never for any management issues or any recruitment. They're out there selling services on behalf of Currency Matters. So they had a Currency Matters email address for that purpose.
Now, are they using this email address to contact with somebody who are not have no any commercial relationship with the Currency Matter and acknowledging type of services not exist?
But the important thing is that those emails suggest that the candidates have been. I think she says that the single candidate acknowledges that
Has been selected.
Yeah, but you then look at the contracts of employment and they're in the bundle. That's exhibit.
So are you trying to say this email has nothing to do with the commercial contract? This is only for other matter or another?
That email address should have only been used in relation to the business of Currency Matters, i.e. generating clients for Currency Matters. Catherine Rodriguez was employed by T-Rex, but she had access to a Currency Matters email address, and she sent that email from that address. But when she does, if you look at the contracts she sends, Your Excellency, are T-Rex contracts. And there they are.
So
they're
why
not
then-
Currency Matters contracts, because there was never a relationship with Currency Matters. And again, I refer you back to the invoice of the 18th of January, which evidences that. which Mr. Ramsey says was a business relationship with Currency Matters, it simply didn't exist. Currency Matters were never invoiced for it, and in relation to the invoices that they now seek payment of, Currency Matters only became aware that these invoices were due in June of 2016.
So basically you are saying Currency Matter is a wrongful party being brought in this proceeding.
Both parties are wrongful, have been wrongfully treated by Mr. Singh and T-Rex Trading. Unfortunately.
So, in another word, you would say the claimant should file this claim against T-Trax,
Yes.
not the currency.
Yes.
And now you are saying those emails has nothing to do with Currency Matter, even though it's been used, they use the Currency Matter
Yes.
email account.
I think you have to take those emails in context, Your Excellency, because those emails refer to potential employees, and the contracts of employment that are attached to those emails are T-Rex employment contracts. They're not Currency Matters contracts.
So, to understand this more clearly, let's say Katharina here, she's sending an email using Currency Matter email, but in fact she's dealing on behalf of with the company
T-Rex Trading.
T-Rex with Mr. Michael.
With Michael Page.
With Michael Page company.
Yes. And the contracts are T-Rex.
And we attached 4 contracts.
There were 2 attached to that particular email, Your Excellency.
Do you have those? You don't have those contracts?
Yes.
You have those contracts?
Yes. And in relation to all of the employees, they were all paid by T-Rex. They weren't paid by Currency Matters.
So why didn't she say that to join our Currency Matter Middle East?
Sorry, Your Excellency.
I mean, she's saying in her email, I mean, those staff already, they joined Currency Matter.
They never worked for Currency Matters, no. Never did.
And they work for whom then?
T-Rex General Trading.
So why she didn't say they will join the T-Rex? Why she's saying that those candidates going to join Currency Matter? This is I cannot understand.
I can't explain that, Your Excellency. I'm sorry, but I can't. But what I can say is that the contracts of employment that were appended to the email were T-Rex General Trading contracts of employment. They were employed by T-Rex, they were paid by T-Rex, they were never paid by Currency Matters. Currency Matters was never a party to this agreement.
Yeah, but the problem here, I mean, for the Currency Matter to give permission to someone using their email address, this is something really...
well, it may be a little naive, Your Excellency, I understand that. But I think you need to look behind the email and what was attached to the email. And it was T-Rex Trading contracts. You have an existing relationship between Michael Page and T-Rex. When T-Rex didn't pay the invoices, they come after Mr. Anderson. That's basically what's happened. Mr. Anderson knew nothing about this until June 2016, when the invoices were paid by Mr. Singh. And they basically used him to alleviate any loss that they may incur. That's the reality of what's happened. And perhaps they should be criticised for that, perhaps they shouldn't. They consider they have a contract. Obviously it's a matter of law whether or not they do. And under the rules of law of contract, interpreting the evidence, in my submissions, there can only be one conclusion, and the conclusion is that there was no authority, never any authority, and they knew, should have known.
I mean, whether the person who signed the contract have authority or not, this is a separate issue. That there is already acknowledgement from the party he did engage in that agreement. In your position, you never engage with the claimant at all in this contract. So the contract does not exist.
Yes.
Then that will follow. All those invoices has no any legal basis, has no any contractual basis. This is your position, straightforward, right?
Yeah.
The other party say that we signed this contract and this contract signed by Mr. Singh, and there is sort of communication between the defendant company and their representatives to hire those candidates. This is your position, right?
Yes, sir.
And as an evidence for your position, you just submit the contract and you submit those emails. There's no any another supported evidence to your position.
That's correct, Your Excellency. We've submitted all the evidence that we had.
Right. And what is now Mr. Singh?
Well, we're still trying to track him
Your
down.
client is working in Dubai, or he's?
We don't have any communication with Mr. Singh, Your
Then
Excellency.
have you been instructed to attend this hearing? I mean, Mr. Singh, yes, sorry,
Yeah.
Mr. Singh with the other party, I'm getting confused. Okay. And did you have the original copy of the commercial contract you just submitted in this file?
So I believe what the claimant is referring to is, and I understand the point is, the first piece of work that we did.
And before we get to this, what I'm asking for, you submit a photocopy of the commercial contract.
For the sales.
Do you have an original copy of this?
I would have to check the files.
Because this might lead to a criminal investigation with the Dubai police somewhere, because they are saying this is a forged signature, or that person who signed has nothing to do with us. So that will lead to maybe the other question. When you sign with Mr. Singh, as he represents himself as a CEO of the defendant, how? And they are saying you have to do some kind of due diligence and see whether that person really is representing this company or not. So how your client was 100% sure he's dealing with the right person? I know you were going to say for a variation of previous, but let's assume there is no previous. Let's assume you are dealing with the person for the first time,
Yes.
and you're going to sign with him a commercial deal where there's kind of responsibility.
Yes.
So,
if you're asking what our process is, Your Excellency, in general, when we're working with a new company?
no, not generally. I'm talking about this commercial deal exactly. So your client signed a commercial deal with a company called Currency Matter, and someone, his name, Judge Singh, pretending that he has a position with that company as a CEO. So what does your client was doing to make sure he's signing with the right person, with the right capacity?
So
Did your client make any kind of historical background, or whether this agreement was signed in the premises of the defendant? What I'm trying to find here, when your client signed this agreement,
Yes.
how he was sure he's signing with the right person, representing the right company.
I understand. So, yes, we met Mr. Singh at the office.
Which office?
Within Emirates Financial Towers.
Okay, this is not a Currency Matter office.
So in the lobby section, if I can call it.
Yeah, this is, okay.
Okay. And I wasn't present at the meeting. Farina Newson, who is the co-signer of the commercial contract, she, a manager of Michael Page at the time, she was the person dealing
I'm
with
not aware of this. I'm aware of the other part. Who was representing the Currency Matter?
Mr. Singh.
Yeah, how you make sure that person is really working for Currency Matter?
His understanding of what the business was, his understanding of the job requirements of what he needed. He gave a very, very clear brief on the business and the type of backgrounds that he was looking for. And it's sort of reasonable to assume once you've met with a client, they give you a clear brief on an organisation, the key selection criteria of candidates they're looking for, that they also then sign a proposal with the company's stamp, all within the confines of the DIFC. It's reasonable then to assume that that person is who they say they are and working on their part.
So you signed that contract in the lobby of Emirates Tower?
I don't know exactly where the contract was signed, Your Excellency, because I wasn't personally at the meeting.
So you wasn't exist when He wasn't wasn't there when the contract was signed.
Correct.
Right?
So with most of our clients, they will typically will send an agreement over email, an attachment. They will then print that out. They'll then sign it, stamp it, and they'll scan it back to us. That's normally how the majority of our commercial contracts are within the UAE.
Okay. So you are saying that there is in this particular commercial deal, assuming it was stamped by the defendant, because there is a defendant stamp, and that contract was scanned to your client, was emailed to your client.
Yes, sir.
Right?
Yes,
Do you have a proof of that?
Yes, if we go into our archive manager, we'll be able to show that the email has actually come from Mr. Singh.
Yeah, come from currency matter.
Comes from Currency Matters, yes, sir. That's the email address that we've been working. Well, when the project was on, that was the only channel of communication that we had as far as email.
Okay, I would like to see a type of evidence. If there is an email came from the currency matter, would attach particular this commercial deal with the stamp of the currency matter, but this should be came from currency matter email, not the private email of Mr. Singh.
I understand, Your Excellency.
You need to provide this within 3 days after this hearing. Copy the other party. And I will open the other party to make any comments on that sort of evidence. So you told me you was in the meeting when Mr. Singh introduced himself to your client?
I met Mr. Singh once for a coffee during the recruitment project, just to update on how it was all going. So my interaction with Mr. Singh was I met him once.
That was before this commercial contract was signed?
After the commercial contract.
After.
Yes.
And he was representing himself as a CEO of the defendant?
Well,
Or he was...
Jai Singh never said to me personally, I am the CEO of Currency Matters.
So you met him as somebody signed a contract with your client?
Yes, sir. Yes, sir.
Right.
Our understanding was he was the representative of Currency Matters who was setting up here in the DIC. So, and for us, in our experience, that's quite a normal arrangement when a brand or a company wants to enter the local market, they will normally have a partner. So for us, having been experienced, that's quite normal. And we met him in the context of he was representing Currency Matters Middle East. Now, as far as actual title, it's not something that he and I discussed.
And you've been instructed by your client, Michael Page, to meet with Mr. Singh?
Yes,
right?
sir.
As your counsel as your private lawyer for the claimant. Thank you very much for that.
Thank you.
Maybe you have any comment on this, and I just want to understand the fact here. Mr. Singh has never worked for Currency House?
Never.
So he has no any relation with the Currency House whatsoever?
There's a service provider agreement that was entered into on the 1st of February 2016, the same day that this agreement was signed by him.
Then you have a service provider, you have a service agreement?
And that service agreement is between Currency Matters Middle East and T-Rex General Trading, of which Mr. Singh is the CEO, or was the CEO. And within that service provider agreement, there are certain parameters which he can implement.
And that agreement does allow Mr. Singh to engage with any...
No. Clause 2 points. Clause 2.3 says...
I want to see this agreement again. I'm not sure if I sent it. This is a new submission or...
Is it in the bundle? It's not in the bundle.
No, I haven't said it until today.
It was emailed to Devonshire solicitors on the 8th of March 2017, who represents you.
Yeah, let me see that. So you're saying there's a separate agreement between you and Mr. Singh?
Yes.
Being a CEO of T-Rex, and probably he was engaged with Michael Page based on this agreement?
No.
No? Can I have a copy of this, or you already have?
Yes, you can have that. Your Excellency. And if you look at clause on page 4, clause 3.2.
Page 4, clause,
Yes.
which clause?
Clause 3.2, 3.32.
3.2?
3.2, and then
Yes.
the very bottom clause, page
Yes.
4. The service provider, i.e. T-Rex, shall not have any authority to incur any expenditure in the name of the account of the company, or, over the page, shall not hold itself out as having authority to bind the company. And that was the same day that Mr. Singh signed, or allegedly signed the agreement with Michael Page. But it was never in the contemplation of the defendants that Mr. Singh could enter into any negotiations without written authority, and hence why the board resolution is in existence, because that was particular to the fitting of the office at Emirates Financial Tower.
Now this service agreement was not filed in the ICT case earlier.
It's referred to in the submissions, Your Excellency, and the clauses are quoted within the submission. But the actual document, no. I mean, it's been in the possession of the claimant since the 8th of March 2017. And indeed they refer to it, I think, in some of their submissions.
And my understanding that the claimant, you are not relying on this service agreement whatsoever, right?
No, Your Excellency, this is, and I'd like to just make sure I've got the correct copy here. So on page 2, it refers to the service provider provides the service of its employee Umar Rinch. So is this the same copy?
The original copy. Umar Rinch. Sorry for that.
Just have a...
Is Mr. Anderson okay to address you, Your Excellency?
No, you cannot address me. You can have a word with him.
Mr. Rinch entered into a service provider agreement separately from T-Rex trading. So they were in an identical format. There was one for T-Rex trading and one for Mr. Umar Rinch.
So Your Excellency, the one I'm looking at here refers to this. Refers to Umar Rinch.
What is Umar Rinch? I'm looking to this.
Yeah, it's a
Middle
recitals of paragraph B, Your Excellency.
B.
The service provider provides the service of its employee, Umar Rinch, to develop the business for the company. So Umar Rinch, who's mentioned in the emails and in the submissions, as has been said by the defendants on several occasions, has never been an employee of Currency Matters. The situation is that there was a service provider agreement for T-Rex trading to develop the business. This is that agreement.
Yeah, so new position with the current case against currency matter, you are not relying to this agreement at all, right?
No, Your Excellency. If the defence would like to submit that as a basis of law, then in accordance, we would obviously then want to review that.
I mean, that was answer to my question, what's the relationship between Mr. Singh and the defendant? And the answer was they have a separate service agreement with Mr. Singh as the CEO of the T-Rex General Trading, right?
That's correct, Your Excellency.
So we'll keep this service provider agreement just for court overall knowledge and information. I'm not relying it in terms of sort of evidence the claimant rely on, right?
I understand your excellency.
Yeah, any further point you want to make, please go ahead before we end this hearing. We're almost 2 hours here.
Just give me a moment. Your Excellency, no, unless you want me to sum up, which I'm surmising you don't.
Yeah. Sorry, say that again.
But no other points
Yes.
to make, new
Right.
points on it, unless you want me to give you some.
No, thank you very much for that. Just asking the claimant to submit to the court sort of evidence, as I said, where this commercial deal
I
came
understand your
from.
excellency.
And then when you submit that document, just copy registry and the defendant as well. Then the defendant might have time just to respond to that sort of
That would be helpful.
new evidence, whatever, within a couple of 2 to 3 days. So you need not more than 3 days, maybe, to go to your archive and find this document. And,
No, the 3 days. If we could agree on Sunday,
yes,
given that today is Wednesday and Thursday, so Sunday would be 2.5 business days. That's plenty of time.
right. And please indicate in your email you're going to send us with the sort of email came from the defendant. If there is an email, just let us know if the original agreement is it in your position, in client position or
I
not.
understand.
Then maybe we'll give you another 3 days to reply to that, and from then we'll reserve the case for the judgment. If both parties are already satisfied with today's hearing in terms of submission, and if there is no any further point you want to make, then I'm done with my part. So should we leave you now and
Thank you, Your Excellency.
expecting the judgment after we need 1 week, like 3 days from each, then
Understand.
after that I will reserve the case for judgment should be taken. Probably a few weeks. The point I'm leaving for my vacation on the 10th of August. So maybe by time you submit that evidence and they reply to it, I'll be already on a holiday for 3 weeks. So probably my judgment will come sometime mid of September.
Your Excellency.
Right.
If I could just make, if possible at all, I would imagine Michael Page, being a large organisation, would be able to find the email pretty quickly.
Yes.
And it's today, Tuesday. Could I perhaps say by Thursday? I say that because
I understand.
currency matters have this hanging over them, and they whilst it's
There
acknowledged.
is no any enforcement application has been made here, right?
I know it.
And if there is that information will be made, I will make to stay with if there's an application to stay until I get my judgment. So
Great.
there's no worry about that. All right, thank you very much for both of you.
Thank you.
Thank you.
All rise.
Should we just leave these on the chair or take them with us?
Hand them back to the security.